Well, for 2 days this week, WikiLeaks founder Julian Assange was in court in London fighting extradition to Sweden, where he's wanted for questioning over allegations of rape and sexual assault, which he denies. Our guest tonight is the London bureau chief for the New York Times. He is also the author of a critical piece on Assange, which led to a falling out with the newspaper. Well, John F. Burns is a Pulitzer Prize winner for his work in Afghanistan. He's been sitting in the court following the Assange extradition hearing. He joined me just a short time ago from Cambridge, England. John Burns, thanks for joining us.
It's a pleasure.
Let's start with where you see this extradition case ending up. Do you think Julian Assange is likely to win it?
I think it's going to be, unlike the recent test series, it's going to be a close-run thing. The arguments on both sides have been quite compelling in the Woolwich Crown Court in London in the last couple of days. There's another half day to go on Friday, and we'll say which way it goes. But whatever decision is made at this point, it's going to go to appeal in the UK, and very likely beyond that. At least Assange's lawyers seem determined to go to the European courts if they lose in the UK, in which case this could go on for months.
Has more detail been led in the case about about what the Swedish prosecutor is alleging happened between Julian Assange and the two women who want him charged?
Yes, there's a great deal of detail now available, although I have to say the hearing in London has been mostly procedural, a lot of rather dry argument between the counsels on the two sides. And by the way, Julian Assange's lead counsel is himself an Australian, Geoffrey Robertson, one of the highest paid QCs in the UK, a flamboyant character, as one might expect of one of your fellow countrymen. But the argument itself has been a bit dry. It has to do with fine points of Swedish law and, for that matter, of British law. And they haven't gone a great deal into the detail, but the detail is available. It's available on the internet. And much of it is rather trying to read. It's very intrusive. And not easily discussable on television.
Well, at this time you can discuss just about anything. So does it remain the case that the gravest offence in Swedish law was his refusal to use a condom?
Well, the way we've been expressing this and trying to summarize it in the New York Times is that all sides, all three parties involved here, Julian Assange and the two Swedish women, agree that the sexual relationship that he had with the two of them was consensual to begin with, and became, as we say rather archly, non-consensual over the issue of whether or not he would use a condom as the relationship progressed. And after that it gets a little bit messy. Now, of course, he says, the women say that he either, in effect, coerced them into sex with either, in the one case, a ruptured condom, in the other case with not wearing a condom at all when the relationship resumed in the morning after the night before. He says it's all lies. And it's become a kind of he said, she said business. The case really centres on one of the three charges that are being investigated. Let's remember he's not been actually charged. There's a strange Swedish term called forceful coercion. There's sexual molestation. These are in the range of sort of misdemeanors under Swedish law. Then there's the more serious one of rape. But there are three levels of rape in Sweden, and this is the least serious of the three. It might very well not be deemed to be rape, even if the prosecution case in Sweden is a true bill, if you will. It might not be deemed to be rape under the law of other countries, but in any case it is deemed to be rape in Sweden, which has, as you probably know, a highly feminized, you might say, body of law on sexual abuse.
Do you think that Assange would get a fair trial in Sweden, considering in particular that it'd be held in camera, no one would ever see the evidence presented or the defence against it?
Well, Mr. Assange's counsel have made very much of that in the hearing of the last couple of days, and I don't think that particular aspect of this is going to carry much weight. It's just, how can I know what is in the name of the district court judge, Howard Riddle, who is listening to all of this, who will decide this? He has no jury. But my sense is that the argument on that point has really gone the way of the Swedish prosecution service, because it's represented by Geoffrey Robertson QC for Assange as being a secret trial, a trial in which his case could never be fairly put in the public domain. Actually, those laws, and they're not peculiar to Sweden, were put in place to protect both sides in a case of this kind. Of course, Assange is unprotected because his case has been, as he likes to say, the subject of 33 million pages on the internet. So he says, and he's probably right, that his is the most publicized rape case in history. But in any event, the argument that has been made before the court has centered very much on the fairness or otherwise of the Swedish legal system, and much of that argument has gone to the reasons why the Swedes hold those cases without press and public present. And I don't think that's going to be enough to persuade Judge Riddle that Mr. Assange should not return to Sweden for questioning.
The other reason he's fighting the extradition so hard is that he believes, or says he believes, the United States will be able to pluck him out of Sweden, essentially take him away, maybe lock him in Guantanamo Bay and put him on an espionage trial. I mean, how likely is that?
Very, very unlikely. That's not to say that the United States will not prosecute him, though I think now that we are something like 6 or more months into this, and the Americans having announced almost immediately when the first tranche of war documents were released that they'd impaneled a task force of more than 100 people to look at the consequences of what Assange has done, but also look at the possibility of criminal prosecution. They've done nothing. At least nothing that has moved the case close to a prosecution, as far as I can see. And as for the question of whether or not going to Sweden would make it more likely that he could be extradited, I think from the argument that I've heard in my own investigations into this, when I've been to Sweden a couple of times on this story, that it's much less likely that he would be extradited from Sweden because of elements of their press law which are specifically designed to protect sources. And in this case, Julian Assange would be very likely to be regarded under Swedish law as a source. There's a very high level of constitutional protection in Sweden for people of that kind. So I think if the United States was inclined to extradite him, they'd much rather do it when he's still in Britain, because Britain and the United States have a extradition treaty which is, separately from this case, a highly controversial issue, precisely because it has so far lowered the barrier that the Americans must cross in order to win a successful extradition case. It's a major political issue here, and the Cameron government has agreed to review that treaty, which has been in place only for 3 or 4 years. So I think the argument that if he goes to Sweden, it's sort of a brief stop on his way to Guantanamo Bay, is in the realm of the fantastic, which is not to say that Mr. Assange himself may not believe that. He has been... He's a redoubtable character, a very Australian character, if I might say so, tough, not easily scared, but he's in a